The First District Court of Appeal is now in session. All who have business before this court draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have 3 cases on the docket today. We will take them in the order that they appear. After the second case, we will take a brief adjournment and invite the parties and counsel to join us in the rotunda for coffee. Following that break, we'll resume and hear the third case. With that, our first case on the docket today is Monroe doing business as McGee Tire Auto versus Jeff Parsons. Counsel, if you're ready, you may proceed.
Good morning, Your Honors, and may it please the Court. My name is Christopher J. Morrow, and I represent the defendant appellant, Monroe, Inc., in connection with this matter, and I'd like to reserve 2 minutes of my time for rebuttal.
So noted.
This case stems from the Florida Commission of Human Rights award of back pay damages to plaintiff appellee Jeffrey Parsons in a disability discrimination case. The Commission awarded Mr. Parsons back pay in the amount of about $370,000, despite overwhelming record evidence that Mr. Parsons failed to mitigate his damages. The Commission did so despite the fact that there can be no dispute that Mr. Parsons failed to engage in reasonably diligent efforts to obtain comparable employment, inexplicably declined 2 substantially equivalent offers of employment from other tire manufacturers in the area, and voluntarily resigned his employment from Monroe on June 19, 2019. The ALJ's findings on all of these points are legally and factually insufficient and require a reversal and a remand to the Commission to send an appropriate amount of back pay damages, if any.
Under what standard do we review whether the employee exercised reasonable diligence and the lower tribunal's determination of that factor?
Yeah, so I acknowledge there's some conflict in our opening brief and our reply brief on that. The typical standard applied to review of damages awards is an abuse of discretion damages, an abuse of discretion standard of review. I do maintain, however, that there are some legal questions in this case that would be more appropriate for a de novo review, specifically what the legal effect of declining a substantially equivalent offer of employment is, what the legal effect of a non-compete agreement is on an award of back pay damages, and the legal effect of a plaintiff's resignation from their employer in terms of their entitlement to back pay going forward. But on the whole, I do acknowledge that it is an abuse of discretion standard in reviewing back pay.
Okay, with that in mind, and let's just take the opportunity that the employee would have to obtain substantially equivalent employment. Doesn't a covenant not to compete create a barrier? And if the employer hasn't relieved the employee of that obligation to comply with the restrictive covenant, doesn't that create a barrier to obtaining substantially equivalent employment?
It could, Your Honor. It could, but that's not what this non-compete does. And there's important factual context to bear in mind with respect to the non-compete. Mr. Parsons, by way of background, operated his own commercial tire shop in Pensacola for several years, and then in 2016 he sold that business to Monroe. And as part of the purchase agreement, Monroe became Parsons' employer, acquired the business, and had him sign a non-compete that's part of the purchase agreement, which states only that he was prohibited from operating, which is the exact word in the agreement, a commercial tire business.
And non-compete agreements are regulated under Chapter 542 of the Florida statutes, are they not?
They are.
And do you know what the damages are for violating a restrictive covenant under 542?
I don't off the top of my head, Your Honor.
Okay, so certainly if the employee is wrong about his interpretation of the agreement, there certainly is some damage that can be incurred, included attorney's fees and penalties, correct?
Sure, that is correct, Your Honor.
Right. So, so are you suggesting that if Mr. Parsons had gone to work for a competitor across the street and served as the manager of the location with no ownership and interest, that your client would not have sought to enforce that covenant not to compete?
That is not only what I'm saying, but that is in fact what happened. And the record is clear that not only did Monroe understand the non-compete to only restrict ownership interests, but Parsons did as well. And the record is replete with evidence of that. The first and most important piece of evidence on that point, and this is nowhere addressed in the ALJ's opinion, is that Parsons himself, at the hearing, was asked what he stood operating to mean in the non-compete agreement. And he admitted at the hearing that he understood the word operating to mean what it means, owning an agreement. And the factual context under which the non-compete arose is important here. Monroe was never concerned with Mr. Parsons becoming employed by another tire manufacturer. Remember, it just bought his business. It didn't want to have bought his business and have him open up another one next door and have to buy that one as well. So Monroe had no interest in restricting him from becoming employed with other tire manufacturers.
And taking all of the business and clients that Mr. Parsons knew, that would not have been at all a violation of the covenant not to compete.
That's not what the non-compete says.
All right, so are you suggesting that it was unreasonable for Mr. Parsons, at least as to the first two positions he was offered, to interpret that agreement to restrict him from that employment?
Yes, not only that it was unreasonable, but that's not what he understood the agreement to mean. And again, there's a crucial aspect of Parsons' testimony here that is very instructive on this point. It's excerpted in our brief at page 19. It's available at the record at page 451. And in that portion of the testimony, Parsons is asked, what did operating mean for purposes of this non-compete agreement? And he unambiguously states that it only restricted ownership interests.
But didn't he also unambiguously state that his understanding of the agreement was that he could not accept the two offers that were made? So, yes, he may have said, I understand this is what operating meant, but in the context of the actual offers that were made, he said, it was my understanding that these would violate the agreement.
There is conflicting testimony on that point, but his testimony on that, his testimony where he avers that he understood the non-compete to restrict employment as well as ownership is not supported by his behavior post-employment and not supported by the record. And it's important to note here what Parsons' only evidence of mitigation is in this case, and that is that in the months following his resignation from Monroe, he looked for Pensacola, Florida-based positions with 3 commercial tire companies, Goodyear, Bridgestone, and Hankook, all of whom participate in the commercial tire industry, and he was looking for jobs in those positions in the Pensacola, Florida area. So if Parsons truly believed that the non-compete restricted employment as well as ownership, why is his only evidence of mitigation aimed at doing just that?
Well, was it the trial court's role to resolve the conflicts in the evidence as to whether the agreement restricted Mr. Parsons from taking the first 2 jobs?
It is, Your Honor, but that does not mean that they're unimpeachable and they cannot be reversed for clear error. And that's what I think that this case is. And the evidence for that is that not only this isn't a situation where the ALJ weighed the evidence on both sides and came to the conclusion that Parsons' credibility outweighed that of Monroe's witnesses. This is a situation where the most crucial evidence in support of our failure to mitigate is nowhere in the award at all. And the portions of Parsons' testimony where he clearly states that he understands what the meaning of the non-compete is nowhere in the ALJ's testimony. The fact that he was looking for jobs, his first step in mitigation was looking for jobs that under his flawed reading of the non-compete would have violated it, is nowhere considered in the opinion. And again, Your Honor had asked previously about whether Monroe would have enforced this non-compete against him had he actually accepted those offers. Again, he did end up filing the non-compete. In 2021, he ended up accepting a position with GCR, one of the employers that ended up offering him employment in the months following his resignation. That employment is well within the geographic scope of the non-compete, and Monroe never once sought to enforce that non-compete against him.
Wasn't it in Monroe's interest not to seek to enforce that non-compete in light of the mitigation?
I don't think so, Your Honor. No. And if one was to consider Monroe's financial interests, again, if he had become employed, or if it had taken the position that the non-compete barred him from becoming employed, it would have possibly been on the hook for paying him a substantially higher sum of damages.
Okay, so let's move on to the voluntary resignation.
Sure.
And your argument there. So you don't contest the commission's finding that there was an age discrimination, there was age discrimination here, and at least as to March of 2018, Parsons was constructively discharged at that point, correct?
I do contest that he does not claim that he was constructively discharged.
Okay, so there was no constructive discharge at all?
No, so, and the crucial document on this point is his settlement at the Workers' Compensation Board. And in that document, he says that this settlement terminates his employment with Monroe, and he agrees not to return to work with Monroe. Now, I understand that the ALJ, for purposes of setting back pay, had used his last day of work, not the date of resignation for submitting back pay. But at the time that he settled his case with the Workers' Compensation Board, that was his formal date of resignation. And that was a voluntary, knowing resignation that was made while he was represented by counsel. And in Parsons' opposition brief, the only argument that he makes in response is that he was forced to accept the workers' compensation settlement. But that is not what happened. That's belied by the record. Mr. Parsons, the document is clear that he made an informed, knowing, and voluntary decision to execute that document while represented by counsel. So he can't claim ignorance of it after the fact.
Yeah, so is it your position that when an employee agrees not to seek reinstatement and voluntarily resigns their position, as a matter of law, they cannot seek back pay?
Yeah, my position, Your Honor, is that back pay as a remedy, in order to be available, the employer either has to be terminated or, if they resign, allege that they have been constructively discharged. Here, Parsons resigned by virtue of the workers' compensation settlement, and he has not alleged that he has been constructively discharged. Therefore, the back pay award in any amount is improper.
So that would include the period of time between his last day at work and the time of signing the agreement? I mean, because the order, of course, brings back pay all the way up to the present.
Correct, yes. So for the period of time that starts from his last day of work and ends with the workers' compensation settlement, he's already received payment in form of the workers' compensation settlement. The effect of the back pay award and the effect of his resignation is that from the date of resignation, he is unavailable to receive back pay because he has resigned and he has not alleged that he has been constructively discharged. And even if the court were to assume that even if the court were to take the position that that was not correct, we maintain that at most, any back pay award should be limited to 6 months, because 6 months after his resignation was the date that he received 2 substantially equivalent offers of employment from GCR and Monroe and turned them down. And again, it's important to, one of the most crucial aspects in trying to discern what the party's understanding of the contract was is first what the contract says. It says operating. Operating is not employing. An employee who is in a sales management position does not operate the business. And again, the factual context in which the non-compete arose is very important here. Monroe was trying to prevent him from starting another commercial tire business after it had already bought his assets. That is the only thing that it was concerned about, and that is borne out by the party's behavior after he resigned. It did not seek to force the non-compete against him, even though under his reasoning he ended up violating it. And I now see that I'm into my rebuttal time. If Your Honors have any further questions, but I will rest for rebuttal. Thanks.
Thank you, counsel.
Morning to the panel. May it please the court, my name is Ryan Barnett. I'm here on behalf of Mr. Parsons. I'd like to address a few of the issues in turn. With regard to the standard of review, as we argued in our brief, we do submit, and I believe it's been conceded that this is an abuse of discretion case under the 11th Circuit authority. The Miller decision, back pay is governed by abuse of discretion. In terms of how the court looks at that question, most of the law flowing from this comes out of the Title VII statute and its binding authority following that. Particularly, I think the Nord case, which we cited in our brief, is helpful. Ultimately, what is left for the court in determining this question of reasonableness is really has to do with common sense, as we argued in our brief. The court is urged to look at particularly the non-compete in the situation. None of the authority that's been cited really deals with a non-compete situation. And in this case, as the Nord decision points out, the burden was on the appellant at the trial court level to show that there had been inadequate efforts to mitigate damages.
So let's assume that the lower tribunal had looked at the evidence and said, well, as to those two offers, we agree that the non-compete agreement restricted the employee from accepting that employment, but we still find that the efforts were inadequate to, reasonably seek to mitigate damages. Would you concede that there would be no abuse of discretion there?
I would.
Okay.
I think that ultimately that would have been a question of fact. That's what trials are for. The trial court's job is to sort through the facts, make those determinations. And as we've pointed out time and again, appellants have come to this court arguing that competent substantial evidence questions are really de novo, or that abuse of discretion are really de novo. And I understand, they're doing what they need to do, but in essence, they're asking for a retrial. They're asking this court to retry this case, and I think that, again, is not the role of the appellate body. The appellate body is to look for legal errors, and I would submit that there are none here.
So was the lower tribunal's determination that operating would include, managing or working in another business, is that unreasonable as a matter of law, or was
No.
there any legal error in that determination?
I see no legal error there, nor do I see any case law that was cited by the appellant on that question. And I think, in particular, one thing that's interesting, if you look at the testimony of the general counsel at the second damages hearing, she acknowledged at that point, and this is important because Mr. Parsons did ultimately take a position in Montgomery, Alabama, but partly it was based on the general counsel being asked at the hearing, is this going to violate the non-compete? And she said no, and that's part of the reason we asked her that. But one of the other things we talked about, and it was made very clear, is that her definition of operating is not supported by the English language. Nowhere in a dictionary or anywhere that the definitions flow from, case law, statute, otherwise, does the term operating mean ownership. They're two separate words. And in Florida, ambiguities are construed against the drafter. As the LJ pointed out, the employer was free to phrase that document however they wished. But by defining it as operating, which is what Mr. Parsons would do as somebody with multi-decades of experience in running tire shops and managing them, that we would submit respectfully would clearly be operating, and it would have been in violation.
Sure.
If I'm reading the record correctly, it said that McGriff Tire offered your client a job as an outside sales rep. So if your concern is that he is managing another entity that might compete with them, how would that fall under management?
I think operating broadly does not necessarily mean managing. Again, operating can be.
How is an outside sales representative an operator?
Well, again, if there is ambiguity, it's on the appellant, I would respectfully submit. Mr. Parsons' interpretation of that language was such that it would violate his non-compete. And if the appellant had clearly defined that term and had made it more broad or narrow or whatever the case may be, I think it would be a different situation. But that language, the clarity of that language is on the employer. They are the ones that draft these documents. They slide them in front of employees, and you sign or you don't. If they want it to say something clear, then it's on the appellant, would be our position.
So, I mean, I'm asking you, do you find that it's reasonable to conclude that one could read a document saying that you can't operate something and you get an offer as an outside sales representative, that it would violate it?
That ultimately, I think, is the question for the ALJ, and the ALJ determined that I think is the issue here. And in terms of abuse of discretion, I would submit that the ALJ's reading did not reach that high threshold.
So let's turn to the voluntary resignation. So the employee entered into the workers' compensation settlement, right? And let's first take the period from March 18 until the time of the settlement. Was Mr. Parsons compensated through the workers' comp settlement for back pay?
As I recall, he did receive some back pay benefits, which I believe the ALJ, as I recall, factored into, there was an offset essentially in his award,
A complete offset for that period?
as I recall.
All right,
Judge, my recollection is that there was an offset for that. I believe in the proposed order that we submitted, that was something we also conceded, that there was an offset granted dollar for dollar for whatever he received for the workers' compensation benefits.
So then, as to the back pay awarded from the time of the workers' compensation settlement going forward, when the employee voluntarily resigned and agreed not to seek reinstatement, what legal effect did that have? And are you aware of any case, any decision where an employee has voluntarily resigned their position, agreed not to seek reinstatement, and then was found entitled to receive back pay?
I'm not aware of a decision that addresses that question, and I don't believe any of the briefs really cite any authority that's helpful on that. What I would suggest is, again, and we pointed to this, I respectfully argue it's form over substance. His employment had been ended at that point, and it's to me, a curious argument to say that although he had been discriminated against, his employment had ended. Later on, he signs a workers' compensation settlement package, which if you look at the documents carefully, anything that purports to suggest that he's waiving any claims have been lined out, they've been changed. I believe that the appellant is arguing for a broad expansion of what that means in terms of common sense. If your employment has been ended, and then you sign a workers' compensation settlement, and as part of that, you resign your employment, which you've already lost, I think that it would be, to me, it does not make sense to say that should bar his ability to recover.
But voluntary resignation has a specific meaning under Title VII, all the anti-discrimination statutes, does it not?
It does, but in this case, recall again that the Workers' Compensation Act is very, very narrow in its jurisdiction and what it covers. This settlement was executed as part of a workers' compensation settlement. It was not executed as part of a general release for a discrimination case or some other action. It was very, very narrowly tailored really to the workers' compensation case. So I would just urge that you have to look at the context of how that agreement came into place.
I agree that, it may not be a general release, but that says that, anything that happened before may actually still be subject to suit, and that, this doesn't waive that. But really here the question is whether there was a termination of the relationship between your client and the employer such that they could not seek back pay after it. So it's really not a question of whether any claims were released that existed during the employment relationship. It's whether he's entitled to something that happened after. Am I missing something?
I think, for instance, if you look at the one case that was cited by the appellant dealt with a situation where an employee had taken another job and then resigned that position. And to me, that the reasoning in that case certainly comports with my understanding of the state of the law. But I think in this case where he had not taken other employment, he was bound by the non-compete, and he resigned or voluntarily resigned as a pro forma part of what is really a workers' compensation settlement in the very, very narrow context of what those courts have jurisdiction over. I respectfully submit there's no authority, there's no binding legal authority that says that bars him from recovery under either Title VII or the Florida Civil Rights Act. So I think that would just be a broad expansion that's not supported by the current state of the law. And again, in terms of abuse of discretion, it'd be one thing if there was a case directly on this that says that the ALJ erred, but there's not. And so I would urge that this would be a broad expansion in terms of what the appellant's asking you to do here. I'm happy to answer any other questions. All right, I'll yield my time.
Thank you, counsel.
Thank you, Your Honors. So I want to continue the discussion on the back pay question. My friend on the other side has stated that there's no discussion in the briefs about whether back pay is proper when a plaintiff resigns their employment voluntarily. That's not true. And the most fulsome discussion of this is at our reply brief on pages 16 and 17. And the case chiefly on point is Pace v. Alpha Mutual Insurance Company. And that case is from a district court in Alabama, I believe, from the 11th Circuit, that specifically says in order to assert a claim from back pay where an employee is resigned, the employee must allege that they have been constructively discharged. And that might sound like a bit of a harsh remedy for plaintiffs, but it's important to remember here that under the anti-discrimination laws, back pay is not the only available remedy. It was the only remedy awarded here, but a plaintiff in this situation where they resign and are ineligible for back pay can also seek punitives, can also seek emotional distress damages and attorney's fees. So while Parsons' argument that it might seem unfair or illogical to have back pay be totally unavailable in this situation, that is the clear command of Title VII and the anti-discrimination statutes, not only in Florida and in the 11th Circuit, but across the country. Where an employee resigns, constructive discharge is the claim that entitles that employee to back pay. And without a constructive discharge claim, any back pay award is improper. I want to also briefly touch on the fact that plaintiff my friend on the other side, both in their brief and in this argument, has emphasized that this is the appellant's burden to show that a plaintiff has not mitigated their damages. That's true. I don't contest that it is our burden. But it's important to remember that meeting that burden rests entirely on what the plaintiff does. And when the plaintiff, as the plaintiff did in this case, does next to nothing, he can't argue that we haven't met our burden because there's no evidence that he failed to mitigate. There is only one piece of evidence in this record that Mr. Parsons made any attempt to mitigate his damages, and that's that he just searched online without submitting any resumes or applications to find a comparable position. That does not meet the threshold for mitigating damages under Title VII or the state analogs. With no further questions, I yield the rest of my time. Thank you, Your Honors.
Thank you, counsel. Thank you both. We'll give counsel a moment to reconstitute for the second case. Our second case on the docket today is Sean Carana and Florida Carry Incorporated versus Rick Swearingen. Counsel, if you're ready, you may proceed.
Excuse me. Thank you, Your Honor. Good morning, Your Honors. May it please the Court, my name is David Katz for the Plaintiff Appellants. May I please reserve 3 minutes for rebuttal?
So noted.
May I proceed?
Yes.
Thank you. In 2011, the legislature amended Section 790.33 to address violations of the preemption statute. The 2011 amendments apply to the enactment or enforcement of any local ordinance or administrative rule or regulation impinging upon the legislature's exclusive occupation of the entire field of firearms and ammunition. 790.33, 3A, requires courts to invalidate and permanently enjoin the operation of any ordinance, regulation, or rule adopted in violation of the preemption statute, Your Honors. If those words sound familiar, they should, because they're the very words written by this court in its ruling in State versus City of Weston. In its answer brief, FDLE repeatedly asserts that the Florida legislature has tasked them with interpreting Florida Statute 790.065. This shows their complete lack of understanding of the doctrine of preemption. The Florida legislature clearly stated their intent to wholly occupy the field of firearms when it passed 790.33. The legislature clarified the intent when it twice amended 790-33, once in 2011 and again in 2021. In the 2011 amendments, the legislature clarified the administrative agencies were included in the wide scope of preemption, as this court noted in the excerpt that I just quoted in the Weston case. Again, in 2021, the legislature amended 790-33, again indicating their intent that 790-33 applied to administrative agencies, and again indicating no administrative proceedings were required when they used the following language in 790-33. If, after the filing of a complaint, no complaint is filed in an administrative hearing, a defendant, there isn't a defendant in an administrative hearing, voluntarily changes the ordinance, regulation, measure, directive, rule, enactment, order, or policy, written or unwritten, promulgated or caused to be enforced in violation of this section, with or without court action, the plaintiff is considered a prevailing plaintiff for the purposes of 790-33. None of the language used by the legislature in amending 790-33 on either occasion shows that the legislature contemplated a party to first have to comply with the dictates of the Administrative Procedures Act and first file for an administrative hearing under Chapter 120.
Well, speaking of rulings that we've already made, we have once discussed whether one would have to exhaust administrative remedies before filing a 790-33 action in the Thrasher case. Why does that not control here? It seems like your arguments are extraordinarily close to the arguments made in the Thrasher case.
And I actually believe that this court's rulings in both of the Thrasher cases do control here. First, in Thrasher 1, which was the 2018 case, this court ruled that Florida Carry would have to go and seek other remedies. It could be a cause of action if they found one that was justiciable, or administrative remedies under 120 when it was speaking about electronic weapons, because this court found that 790-33 applied to firearms. In that same case, however, this court remanded back to the trial court for clarity of record to determine whether or not 790-33 would allow Florida Carry to seek action in court on the firearm portion of the case. So that's the first time this court said that there was a court action available under 790-33. When it came to Thrasher 2, the 2021 case, this court looked at Florida Statute 1001, I believe it's 706, in which the legislature specifically told the university's Board of Governors that they could regulate firearms and were to come up with administrative procedures for violations of Florida Statute 1001-706, which an aggrieved party would have to follow if they wanted to bring in a complaint under 1001-706. That was a specific mandate from the legislature. Here, there is no specific mandate in 790-33 that requires the following of administrative procedures. Not once does the legislature use the words administrative hearing. They never use Chapter 120. They never say that a person has to take a proceeding in front of an administrative law judge. Nothing. What it says is that a person can bring an action in any court with jurisdiction over the defendants.
I don't know. It's the same 790-33 that was at issue in Thrasher, and instead of the 1001-706 FDLE, which is a lot of their actions are controlled by the Administrative Procedures Act. There is an act that controls what they do, what challenges can be made to their actions, what their responsibilities are. I'm having a lot of trouble distinguishing what Chapter 120 requires of FDLE and what Section 101-706 requires of universities. In either case, you're claiming that 790-33 allows you to bypass the administrative proceeding and file the suit.
I'm not claiming that when it comes to the Thrasher case, because the legislature specifically wrote a law requiring 1001-706 specifically wrote a law directing the Board of Governors to come up with an administrative proceeding by which people who had complaints under 1001-706 must have their...
So FDLE doesn't have any kind of mandate from the legislature to pass regulations on how they handle firearm licensing and whatnot?
FDLE has a specific grant of authority to do very specific things that the legislature tells them exactly what they are in 790-065. Under 790-065, FDLE was told that they should promulgate a form to be used for the purchase of a firearm, that they could impose a fee no greater than $8 for a background check against those who do not hold a valid CWFL or against law enforcement officers. They were told to come up with procedures for the payment of said fee, rules for the correction of incomplete or erroneous criminal history records, regulations to ensure the privacy, confidentiality, and security of those records. Florida Statute 790-065, subsection 6 makes it clear that all other procedures are established by this section and not by agency rule or regulation. The legislature told them, do this. They don't get to do more than they're told when the legislature preempts the entire area of law. And in this case, not only did they do more than they were told, they did the exact opposite. They clearly exceeded the authority given to them. They were told to run supplemental background checks and collect a fee for the purchase of a firearm, and they were told you cannot do that if the person holds a valid CWFL or an active certification as a law enforcement officer. FDLE then wrote a rule which gave no credence to the fact that they were told do not collect this fee from people who have a valid CWFL or law enforcement officers, and wrote a rule to collect the fee from everybody who purchases a firearm, and to run those background checks that they were told not to run against those same people, against the people who, again, are law enforcement officers or hold a valid CWFL.
Mr. Katz, could you please address some language in 790-33, specifically subsection 4, which deals with exceptions, and I'm honing in on subparagraph D, where it says this section, referring to 790-33, does not prohibit a court or administrative law judge from hearing and resolving any case or controversy or issuing any opinion or order within its jurisdiction. Doesn't that contemplate that the legislature knew that there may be some instances where an ALJ may be asked to weigh in on certain things under 120?
May I have just one moment, Your Honor? I know it takes my time. I just want to pull that up if I can figure out how to on my iPad.
And again, it was subsection D, subsection 4, subparagraph D.
I don't have an internet connection, so I'm not going to be able to pull that up on my iPad. I'm sorry, I don't have that in front of me. But the specific section that talks about remedies makes no mention of administrative administrative proceedings at all. What it specifically says is that a suit can be brought in any court with jurisdiction over the defendants. And that language is clear. The legislature is presumed to have knowledge of court rulings and the way that the court interprets language, and it specifically chose the language in the sections that I've quoted to not include anything about administrative proceedings. And
But isn't there similar language in other statutory provisions that provide pathways to bring suit? So, for example, Chapter 86, the Declaratory Judgment Act, that provides a pathway for someone who's uncertain about their rights under a statute, will, contract, to come into court, and it gives the circuit court's jurisdiction to adjudicate those when there's a justiciable case that meets the requirements. And, certainly in DEC actions, this court has affirmed decisions requiring exhaustion of administrative remedies, and that Chapter 86, doesn't talk about administrative remedies necessarily. So how does that not apply here?
Sure, and that's actually a very easy answer, because the legislature did not occupy the whole field. Here, under 790.33, the legislature has occupied the whole field. They've specifically said we can sue in any court, and for a court to take a judicially mandated rule, which is what exhaustion of administrative remedies is, it's not in the legislation, and apply it to 790.33, would be substituting themselves as legislators instead of as the judiciary.
Well, they've certainly occupied the whole field, but again, as I pointed out in subsection 4D, they acknowledge, that 790.33 doesn't prohibit a court or administrative law judge from exercising their jurisdiction when it's warranted.
Right. When they have jurisdiction, such as this court found over electric weapons. Okay? Here, an administrative law judge wouldn't have jurisdiction because specifically 790.33 reserves the actions that we've brought, at least, to courts. It specifically says court that has jurisdiction over the defendant. It doesn't make mention anywhere of having to have an administrative proceeding first.
So assuming that exhaustion of administrative remedies does apply here, what are some of the exceptions and which one is your best?
Absolutely.
One that
and
you
so there are two. The first is that FDLE has clearly exceeded their authority because the rule they've put in place is the exact thing they were told not to do. Okay? They were told don't charge a fee if a person holds a valid CWFL or is a law enforcement officer. They ignored that. That's a clearly exceeding their authority. And I know I'm in my rebuttal time, but I do want to finish your answer. The second one we were a little bit wrong about in our brief, and I apologize, but FDLE, we said that the plaintiffs would not be able, the purchasers of firearms would not be able to get money from the state treasury because it was segregated into a trust fund. We learned from the brief of the appellees that the trust fund is part of the state treasury, so that wouldn't apply. But they also pointed out something very important. The person who can get a refund from the state treasury is only the person who paid the money into the state treasury. Our plaintiffs who purchase firearms by rule pay money to the federally licensed firearms dealer. That money is held until a monthly invoice is sent by FDLE and then paid by the federal licensed firearm dealer into the trust fund. The only person that can get a refund from that is the dealer, not the purchaser. So there is no remedy for the purchasers under the Administrative Procedures Act. If it's okay, I'll save my last minute for rebuttal.
So noted.
Thank you very much.
I will add an additional minute to your time for rebuttal, and I'll correspondingly give an additional minute to the appellee as well.
Thank you.
Thank you, Your Honors. May it please the Court. My name is Jeff Slanker, here with Kristen Dia, representing this fellow in PA. I'm also here with Jim Martin, he's the General Counsel of the Board of Arbitration. I have the privilege of representing the Department of Law Enforcement in this case, and I want to start with something that counsel said just now and something that was in the brief. I believe this was in the reply brief. They made the comment that their contention is that the department has acted without any authority to regulate firearms in the way that it has. And what counsel just said today was that we, evidently, the department in issuing this rule, did more than what we were told in the statute. This is a rule challenge. That is exactly what 120.56 was created to address. The allegation, right, that the plaintiffs are making in this case is that the department has contravened the statute. That's an ultimate statutory interpretation issue, and that is what Chapter 120 is for.
Well, certainly Chapter 120 governs rule challenges, but what about their contention that there's no mechanism to get the refunds, therefore there is no adequate remedy under Chapter 120?
So, Your Honor, I would say two things in terms of the refund issue specifically. The notion that there's no ability for them to receive any type of relief through the refund statute for funds wrongfully paid or funds that shouldn't have been paid into the Treasury in error. That was an argument in terms of ultimate ability to obtain that relief that wasn't pressed below. It wasn't argued in the initial brief. I would assert, Your Honors, that that's been waived. The entirety of the argument on that ground was the funds go into the trust fund, and therefore it's not available because that's not the Treasury. I don't necessarily read the provisions of 21526 the way that my friends on the other side do. I know that there are some cases that talk about who bears the burden of ultimately the fee. And I apologize, Your Honor, obviously this isn't in our papers because it didn't come up until the reply brief. But there's a case, I'm going to butcher the name, Szabo, S-Z-A-B-O, and then Daystar Farms. And the Szabo case is 286 Southern 2nd 529. It's a Florida Supreme Court case, and Daystar Farms is 803 Southern 2nd 892, and talks about who bears the burden of the ultimate inappropriate. I believe in those cases they were tax cases. So I would say a few things, Your Honor. I would say there absolutely is an adequate remedy. If you look at the Sarnoff case, it's kind of exactly what they're doing here. They're challenging what they say is a misinterpretation of an agency rule that assessed a fee that wasn't supported by statute. And what the Florida Supreme Court case, or what the Florida Supreme Court said in Sarnoff was, you have an adequate administrative remedy for that situation. Go to challenge the rule in 120.56, and then you seek a refund as appropriate for the Department of Revenue. So ultimately, I think, frankly, the issue of can they be refunded, can they seek that refund, it ultimately almost brings another issue to the forefront of my mind. And again, Your Honors, not an issue briefed because we would again submit that this wasn't preserved. It wasn't put before the circuit court. It wasn't put before this court until the reply brief. But that, to me, creates issues of standing. And that's another prudential doctrine that courts have, including appellate courts, to determine if they're standing to assert entitlement to even obtain relief. So if they're saying that there is no remedy, and they cannot be remedied, there's another prudential concern that speaks to jurisdiction courts, circuit court, or this court, and that's the issue of standing. I want to kind of pivot back to the notion of 790.33 and Chapter 120 can't stand together. And I wholeheartedly agree with that and believe this case is completely controlled by Thrasher. Nothing in the provisions of Section 790.33 suggests remotely that it is to be interpreted to render Chapter 120 a nullity. It would, the interpretation advanced by the plaintiffs would read the statute out of existence, because I think ultimately what they're claiming is really that the department didn't exceed the authority, but misinterpreted the statute in implementing its authority. And that's clearly a rule challenge. The provision in 790.33, it says that the preemption statute shall control except as otherwise provided by general law. And we'd submit, of course, that the Administrative Procedure Act is general law. It's part of
Where in the Procedure Act does it say that one must exhaust remedies under that act before they can file a statutorily permitted lawsuit?
Your Honor, I don't know that there's any necessarily specific language, or at least not language that I included in our brief in particular. And I think this gets to maybe the issue of, is this a question of jurisdiction, or is this a question of judicial policy? I think that generally how courts have addressed this issue is, in these situations, we should let the agency create a record, develop a record, and allow for the ability to explain the reasonings and the rationale for why a rule was implemented the way that it was before stepping in and exercising jurisdiction. I look at the Brock case, it's one of this court's cases, and it talked about just that. It was an issue of what was ultimately being posed was statutory interpretation. And what the court said was statutory interpretation, yes, is ultimately the province of the jury, or of the court, the judiciary, excuse me. But courts should allow agencies to be able to go through this process, establish a record, and at that point, there's a judicial review mechanism through 120.68 for this court to then review that record and determine if that ultimate statutory interpretation resolution of the agency was appropriate. And I think that that is what this.
Can a court not make that determination in a 790-33 lawsuit?
Can a court make the
Sure.
determination in terms of?
Sure. Why does it have to be by an ALJ at DOA?
Your Honor, I think that it's part of the doctrine of exhaustion of administrative remedies that courts have set up and established throughout a number of cases and precedent. And I look to really the Falls Chase case that this court spoke on, whether to exhaust administrative remedies and whether that was required, and what the court said in Falls Chase, and this is what it also said in the Thrasher case, is said that the enactment of the new administrative remedies in Chapter 120 severely curtailed the need for extraordinary judicial relief, such that only exceptional cases courts may assume jurisdiction and render relief without requiring exhaustion of administrative remedies. And I think that's the notion of, we have the system set up. The Florida legislature specifically set up the system to particularly address challenges to alleged invalid exercises of delegated legislative authority. And I think that that is exactly what this court recognized in the Thrasher case. We've got 1001.706, and it provides a similar rule challenge procedure as Chapter 120. And my understanding of that procedure and just my read of the procedure is it tracks almost exactly, if not exactly, the language of Chapter 120 and was modeled after Chapter 120. And it allows rule challenges similar to those that would be brought under 120.56 to be brought when the Board of Governors or University Boards of Trustees are engaging in their rulemaking authority. And I think it's telling, right, that this court in Thrasher relied on Falls Chase. And what this court in Thrasher said was, no exception applies here such that Florida carry is required to exhaust an available administrative remedy.
Okay, and let's pick up there on the exception to the exhaustion requirement that's argued here. So what would FDLE have to do to exceed its authority under this statute before the appellant could go directly to circuit court?
Your Honor, I think that it would have to be, I think that there would have to be a regulation of a statute that, or the implementation of a regulation on a statute that it's not been authorized at all to interpret or not been, I guess, been empowered or given the responsibility to perform any function related to it. And
So let's hypothetically say that the statute said that, FDLE may charge fees to all people over the age of 18, but may not charge anyone under the age of 18. If FDLE started charging that fee to someone under the age of 18, would it have exceeded its delegated authority?
Your Honor, it's hard for me to grapple with that hypothetical, and maybe that's why it's a good hypothetical, right? Just because I think the language in that situation is certainly different from the language that we have in this situation. But ultimately, I would say, if it's a question of statutory interpretation in terms of whether the agency has exceeded their delegated authority, that issue should ultimately go before the administrative hearing body.
What if the
That should
statute
be-
says that the agency has no delegated authority to charge a fee to someone under the age of 18? Would they still need to go to the ALJ for a resolution of that issue?
I think that might be a different situation in which the legislature explicitly said that there's been no necessarily delegated authority. I think in this situation, of course, it's a little bit different. We have two sources of authority. There's 943.04. That talks about, and it really actually, it requires the agency, the department to adopt rules pursuant to 120.536 and 120.54 to implement the provisions of law conferring powers or duties upon it. If you look at 795.065 itself, that provision, which concerns the background check system in Florida, requires the department to establish rules for the collection of fees, and the provision in subsection 2 of the statute obviously places the responsibility and the duty on the department to run background checks as an incident to firearms purchases. So that language, the language in 943 and the language specifically in the statute commanding the department to adopt a rule to implement this statutory language is exactly, the rule is exactly consonant with that authority. And I think the issue in this case, and really where I disagree with plaintiffs, is that they're conflating the ultimate statutory interpretation issue of, well, what does this subsection mean in terms of the larger statute, and how do they interact, and what's the context of the statute? And that's all, those are all great questions, and they're questions that should be left to the department to allow themselves to create a record in the administrative forum and to explain the reasoning and the rationale. And of course, there's a judicial review mechanism for that. And I think that there's two cases that really kind of illustrate this, this issue. And the first case is Falls Chase, and the second case is Thrasher again. And Falls Chase, what this court was confronting was a situation in which the Department of Environmental Protection attempted to regulate the dredge and fill operations on a piece of property. And the statute said you can only regulate based on plant and soil indices. And they said, well, we're going to regulate based on ordinary high water line. And nowhere in the statute and nowhere in any provision of grant of authority to the Department of Environmental Protection were they afforded the ability to regulate on these types of grounds. And I'm not a environmental law guru, and I'm not a scientist. The court does a good job in that case of explaining some of these concerns, but that was a situation in which someone was acting, or the agency was acting outside of their delegation. You look at Thrasher, and I think Judge Long's concurrence really kind of explains the issues in Thrasher. In Thrasher, the university had statutory authority to regulate firearms. And that's much like this case. The department has a statutory authority, has a responsibility in 943.03 to implement rules. It shall implement rules to regulate firearms. Now, there's a difference in the Thrasher case. There's a difference of opinion about how a statute interacted with the rule and whether they can be read side by side. The argument in that case was, did the rule improperly require that long guns be concealed in private conveyances on university property? The issue here is the extent to which a fee applies to certain purchasers. That's a question of statutory interpretation. That's a question about whether the rule contravenes the statute. That should be an administrative forum, and that's why this court should affirm the lower court.
Thank you, counsel.
May I proceed?
May.
Thank you, and thank you for the additional time. I think I'm going to need it. Judge, Your Honors, just a minute ago, my friend on the other side here said that FDLE has the power to implement. I agree. That's the power they have. Unfortunately, they're not just implementing, they're interpreting, which was part of their rest of their argument. FDLE has consistently argued this is a simple difference in interpretation of 790.065. But there is no reasonable interpretation that would allow FDLE to interpret the words of the statute in direct opposition to what they say. The words say holders of a CWFL or law enforcement officers are exempt from the background checks and the fees. There's no interpreting that in any way that allows them to collect fees and run background checks on holders of CWFLs or active law enforcement officers. And I did have a moment, my co-counsel was able to pull up the statute that you had asked about earlier, Your Honor. And yes, of course, the court was right in pointing out that it says that a court or administrative law judge can hear any matter within its jurisdiction. Here, in the same statute, under penalties and prohibitions, subsection 3F, the legislature specifically says who has jurisdiction in this case when they say a person or an organization whose membership is adversely affected by any ordinance, I'm going to skip a little, but rule, may file suit against any county, agency, municipal district, or other entity in any court of this state having jurisdiction. If we can't file in a court, why would they say we can file in a court? I thank you for giving me the extra minute. I believe I've used it. So if you have no further questions,
Thank you,
thank you
counsel.
for hearing us today.
Thank you all. This court will take a brief recess, and we invite you to join us in the rotunda for coffee.
All rise.
I like it better when I don't like it. Yeah, I do. Makes you look good. You want to stay for golf? I would stay a while.
Sure.
A lot of times the coffee is before the argument.
Oh.
It's always supposed to go out. Was it everything you thought it would be, Kirsten? No, it's not my water. No, we're parched. Is this still being broadcast or are cameras off? I can't hear you, I'm sorry, I'm going to come closer, if that's okay with you. No, not at all. Drinking water. Not at all.
This your first one?
My first one.
Oh, you did good.
I had to ask Mr. Slanker where I sat. Okay, which side do I go? Thank you, by the way.
Yeah. All pro.
I don't like doing new things. Not at this age.
Well, no one does, but you know, this is where like sort of growth lies,
Yeah,
right?
no, I agree.
I didn't know they stopped doing that. I would think so. I think should be about time.
Yeah, I know, we really know how to clear our room, huh?
All rise.
Please be seated. Our final case on the docket today is Elizabeth Lyon Hall versus Green Bandit Lawn Care. Counsel, if you're ready, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Mike Weiner. I'm here on behalf of the claimant, appellant Elizabeth Lyon Hall, who is the court-appointed guardian for an injured worker by the name of Alejandro Lopez, who was rendered completely incapacitated as a result of a work injury that he sustained. I would like to please reserve 6 minutes for rebuttal.
Okay, so noted.
So the case starts with very tragic circumstances. On February 11th, 2021, Mr. Lopez was working as a landscaper for his employer in the course and scope of his employment, edging around a pool, when for unknown reasons he fell into the pool. Unfortunately for Mr. Lopez, he never learned how to swim, and as a result, some 30-40 minutes later, his coworkers found him at the bottom of the pool. They fished him out. He was taken immediately to the emergency room, but it became quickly apparent to all persons concerned, including the carrier, that this gentleman had suffered very serious injuries that would render him now and forever in a permanent vegetative state. So the carrier knew from the very outset of the case, within 1 or 2 days after having received notice of the injury, that they were dealing with the claimant who was completely incapacitated, who had no ability to make any medical decisions on his own, who had no ability to make receive indemnity benefits on his own or do anything on his own behalf. Curiously, though, even though the carrier was armed with this knowledge, just 4 days after the accident, it marched into the Judge of Compensation Claims office on an ex parte hearing solely for the purposes of wanting to obtain and preserve blood and alcohol, blood samples regarding the injured worker. So we see at the very outset that the carrier's motivation was not how do we take care of this injured worker, but really, unfortunately, is there a possibility that we can deny this claim based on an intoxication defense?
Would it have made any difference if they had not taken that action, if they had immediately gone to the JCC and sought a guardianship for Mr. Lopez?
Well, I think under the self-executing nature of the workers' compensation law, that's what the carrier should have at least done. We're not saying that the carrier had the responsibility of filing all the papers, but at least alert the judge and say, hey, Your Honor, 44017 says that you have, a discretionary authority to go ahead and appoint a guardian for a totally incapacitated person.
Does the JCC have the authority to appoint a guardian?
Well, the JCC, it says it can appoint somebody to receive the benefits. There are two separate guardianship concepts here. We talk about 440.17 in terms of a guardian in the context of workers' comp, but then there's the separate guardianship provisions that exist elsewhere in the Florida statutes, and those are the protocols that we were compelled to follow because the carrier never did anything to sort of assist Mr. Lopez with having somebody who could be the legally proper person to receive his workers' compensation benefits and to make medical determinations on his behalf.
Well, I'm glad you mentioned the guardianship statute because, certainly the provision for appointing a guardian under 440 or seeking the appointment of a guardian does not operate independently from 744. Isn't that correct?
Correct. I think they're supposed to be sort of read harmoniously with each other, and that was obviously not done in this case.
Right. Well, and correct the court if the court is incorrect about this, but was there not an uncle who was involved who purported to receive indemnity benefits early on in this case?
Yeah, there was an uncle the carrier had reached out to early on in the case, and he sort of, with just a quick telephone call with no real investigation as to whether the uncle met any of the legal requirements to serve as in the capacity of a guardian, and he just said, I'll be handling everything for the injured worker for now.
Okay, so understanding the facts then, we get to the appointment of a guardian. The guardian here was appointed under 744, correct?
Correct.
All right, and doesn't that chapter also provide for the payment of costs and fees to a guardian and how those should be obtained?
Correct.
And our fees for a guardian, are those submitted to a JCC for determination or for the court, with the court being defined under 744 as the circuit court?
Procedurally, to answer your question, excuse me, it's a good one. The guardian would have to petition the guardianship court for payment for her services. In other words, that I've had to go out and spend X number of hours to provide benefits on behalf of the ward. That gets approved by the guardianship court, and then the judge of compensation claims, in turn, is given the authority and the jurisdiction to order reimbursement from the carrier to the claimant. And that's exactly what we've sought here, and that's where we assert that the judge committed legal error by failing to reimburse the claimant for the guardianship expenses that he incurred as a result of being able to set the guardianship up on behalf of the ward.
And to be clear also, the expenses that were incurred by the guardian were not expenses that were incurred for filing a petition to secure compensation for the ward or to secure some other type of benefit that was not already being provided by the employer.
That is correct, Your Honor. This was sort of what I call the ab initio, right? You got to have the egg needs to come first before the chicken in this metaphor, right?
So the administrative costs of the guardianship.
Correct.
Right.
Correct.
So, all right. And so stay with me then. It seems that Chapter 744 anticipates those very expenses to be incurred under that chapter. And in fact, it imposes on the guardian certain duties, including, marshaling the assets, accounting for the assets, also to seek and make provision for the medical care of the ward. So those are all 744 obligations, administrative obligations of the guardian. So why should those costs and expenses not be awarded under 744 as they are with any other professional guardian?
Well, they are awarded by the guardianship court under that chapter to the guardian. And now the guardian turns around and seeks reimbursement from the workers' compensation carrier for reimbursement for those services under 440.17. So our position is that it is an incorrect reading of the statute, as well as, more importantly, the case law, which is there's really three cases that have interpreted. We've got Lavoie, Charlton, and then the Valdez case, to a lesser extent, interpreted this. Interestingly enough, in both the Lavoie and the Charlton case, you can read between the lines and sort of see that the establishment of the guardianship seems to be fees or expenses that were awarded by the JCC and approved by this court. It's the ancillary matters, right, that where the problems come into and the questions come in. In Lavoie, for instance, the court talks about the guardian performed a variety of services for Lavoie in addition to pursuing the claim. So, there's a whole universe of things out there. In Charlton, there was this issue of, criminal court proceedings, which the guardian was compelled to attend, which this court said, no, you can't get those. And what I think the Valdez case did is sort of put a nice little bow on this and interpreted these cases as saying, okay, there has to be an inherent link between whatever the services are that the guardian are providing and the workers' compensation case, right? And we've heard this sort of, this causation sort of link exists everywhere in workers' compensation, whether we talk about major contributing cause, whether we even talk about advances, and there having to be a plausible nexus for the need to it, for the advance with the work injury. And, the Valdez case talks about this necessity of an inherent link. And we would submit to you that under that decision, as well as under Lavoie and under Charlton, there is absolutely, undeniably, an inherent link between the workers' compensation case and his injury and the services that the guardian provided.
But how is that different than, let's say, a personal injury suit where an insurer, compensates a plaintiff who has been injured in the way that the workers' compensation system does, and then the guardian is paid under the authority of the 744 from the assets of the ward. And so here, the ward received indemnity benefits that the guardian is administering. Typically, with that kind of income and asset available, the guardian would seek reimbursement under 744 with the approval of the circuit court. Why isn't that the correct method for recovering these administrative costs and the costs of, making sure that the ward is getting the medical care he's entitled to?
Well, I would submit to you that in a personal injury case, part of the damages that can be claimed would be the damages of the expenses for the guardian. those are things that you would sue as part of your economic damages against the tortfeasor, and then you would presumably be awarded those by the jury or by the court. And so that's all subsumed in what you get. So again, does the ward individually pay them? Yes, but he pays them only because he's been given the full right of his recovery, assuming he makes his recovery as part of his, those are part of what his damages are. And, you know, I don't think workers' comp really operates any differently, you know?
One final question for me, and I know that my panel members may have others. So how is this to work? Does the guardian first get approval from the JCC for the costs that have been incurred and then go back to the guardianship court? I mean, how 744 is clear that there needs to be approval by the circuit court. So is there kind of like a double process here?
So it is a double process, and it's a good question. And I think the way it is intended to operate and the way we've seen it operate, and this is kind of spelled out a little bit in Lavoie. In Lavoie, you see that the attorney went to the guardianship court. In the circuit court order, there was $8,500 in guardianship court, in guardian fees and costs, et cetera, that were awarded. Then the claimant went to the judge of compensation claim and said, I want that back. And this court said, you get part of it back, but you don't get all of it back, right? In other words, the judge of compensation claims role upon the guardianship court approving these fees and costs and expenses being paid to the guardian is to say, okay, what is it that's, you know, has an inherent link to the workers' compensation injury? Which of these tasks that the guardianship court has approved payment for are related to the handling of the ward's right, responsibilities, and duties under Chapter 440, including but not limited to. And this is where we think the judge made a huge mistake, right? Because the judge treated this as a you know, just these things and these things only. But in Charlton and Lavoie, it talks very clearly about including but not limited to. So there are a whole other set of things. But the things that this court gave an example are collection of benefits under Chapter 440. Unquestionably, that's what Ms. Lyon-Hall did here. Number two, obtaining medical services for the claimant. That's exactly what she did here. You don't have to have denied medical care to require the need of the guardian to be able to supervise and make sure the claimant's getting proper medical care. And then last but not least, obviously, representation of the claimant and claims or proceedings before the JCC. Save the rest of my time for rebuttal,
Thank you, counsel.
unless there's any other questions. No?
May it please the court. Good morning, Your Honors. My name is Allison McInvale, and I'm here today on behalf of the appellee, the employer, Green Bandit Lawn Care, and its workers' compensation insurance company, FCBI, and their servicing agent, USIS. Your Honors should affirm the judge of compensation claims order because the appellant failed to preserve her objections to the order. Appellant argues in her reply brief that she made the same arguments at trial as she did in her initial brief, which is true. In fact, in some parts, it's verbatim from the trial memorandum submitted prior to final hearing and the initial brief, it's word for word. However, what appellant is appealing here is the judge's final compensation order. That is what's at issue here. And appellant is taking the position that the judge of compensation claims made errors in that final compensation order. And the case law, specifically the Hamilton case, the Holland case, and the Jellison case, all direct in workers' compensation matters, that to the extent there's a reviewable issue that arises for the first time in the final compensation order, that the appellant has the obligation to present to the judge of compensation claims in a meaningful way the objection to that order. And the purpose of this, Your Honors, is to prevent parties from taking advantage of the appellate process without allowing the judge of compensation claims the opportunity to address the errors perceived in the final compensation order. In workers' compensation matters, there's a procedure for this. It's found in the Florida Administrative Code at 60Q-6.122. And it instructs that a motion for rehearing be filed if two circumstances exist. One, to challenge rulings that were outside the scope of the issues presented, or two, most applicable in this matter, to seek clarifications in matters of law or fact that the judge might have overlooked or misapprehended. Here, appellant failed to file a motion for rehearing or otherwise bring her objections to the final compensation order to the judge's attention before filing the instant notice of appeal. There's no way appellant could have raised her objection to the order before it was entered. So to argue that appellant made the same arguments below that they're making here now in the appeal makes no sense, because how can you argue a perceived error in a final compensation order before it even comes out? If you're going to argue that the judge made a mistake in the final compensation order, whether in fact or law, it is the appellant's obligation to bring that to the judge of compensation claims' attention so that he or she may address the perceived error if appropriate. In appellant's initial brief, appellant states multiple times that it's appellant's opinion that the judge of compensation claims erred, and I'm quoting from the initial brief, erred in not awarding guardian fees, or incorrectly treated the guardian services as if they were taxable costs, or erred as a matter of law, or erroneously interpreted 440.17, or erred because the judge imposed a new test for reimbursement of guardian fees, or the judge imposed the wrong legal test. The judge misapplied Charlton. The judge misapplied Lavoie. These are all statements that come directly from the appellant's initial brief. The appellant also claimed that the judge erred by failing to consider certain facts as to the handling of the injured worker's rights. Appellant even argued for de novo review because it's appellant's position that the judge of compensation claims misapplied the law, specifically 440.17, the Charlton case and the Lavoie case. These are exactly the reasons why a party would file a motion for rehearing under 60Q-6.122, to point out to the judge of compensation claims that he or she made an error either in facts or in law to be addressed before filing an appeal. Therefore, to the extent the appellant is taking the position that the judge overlooked facts or overlooked law or misapprehended or misapplied the facts or law, or seeking any kind of clarification to the order, the appellant should have filed a motion for rehearing before coming here today. And there is no record evidence the appellant filed any kind of motion for rehearing.
On the merits, under what circumstances is it appropriate for a JCC to award costs or fees to a professional guardian?
Yes, and the Charlton and Lavoie cases speak directly to that point, Your Honor. Under the Charlton case, this court held that guardianship fees are awardable only to the extent they are incurred in and about the handling of the claimant's rights, duties, and responsibilities, including but not limited to such activities as the collection of benefits, obtaining medical services for the claimant, and representation of the claimant in proceedings before the JCC. In the Lavoie case, this court instructed that employer carrier, or instructed the judge of compensation claims to address to determine what guardian fees would be payable for services the guardian performed in the course of pursuing that injured worker's benefits. And those are the words that the judge of compensation claims relied on in his order. The fact of the matter is there is absolutely no record evidence of any activity pursuing or obtaining any benefit on behalf of Mr. Lopez engaged by the guardian. And in fact, the guardian failed to meet her burden of proving that she pursued or obtained any benefit on behalf of Mr. Lopez. The record is clear and it's uncontroverted that the Workers' Compensation Insurance Company never withheld any benefit, never denied any benefit. They've been providing benefits to Mr. Lopez since day one. He continues to be in a long-term care hospital that the insurance company continues to pay for every single day, providing every need since the date of the accident, now nearly 2 years ago. The judge of compensation claims found that the insurance company provided benefits uninterruptedly, never denied anything, never withheld anything, and they did provide the quick and efficient delivery of medical and indemnity benefits as is required under the statute under 440.015 as pointed out by appellant.
Where do we get that the fees are not recoverable unless they are in pursuit of the rights? And I don't mean the Lavoie case itself, but where do they get that from in the statutes, that they're limited in that way?
And by they, Your Honor, do you mean appellant?
No. I mean us, anyone. From where do we get that rule that this is only recoverable if it's in pursuit of compensation claims? Where did Lavoie get that from?
That's a good question. And I think the Lavoie got it from Charlton. I think in the Charlton case, when it says collection of benefits, obtaining medical services, and representation.
Okay, maybe you know what my next question's going to be then. Where did Charlton get it from?
Well, Your Honor, that's a good question. I think that there needs.
I mean, I just want to know where, we have these case law requirements, but I want to know how they fit in with the statutory scheme rather than just what the cases say.
Well, there is no statutory scheme for imposing guardian fees on an insurance company. 44017 says nothing about who pays for the guardian, who has to pay to establish it, or even who has to establish it and set it up in the first place.
Okay, so perhaps those requirements are related to the costs provisions that can be collected in under a 440 action?
Well, and I think that's an analogy appellant tried to make, that the judge of compensation claims erred in imposing some sort of a new test, that it's a prevailing party type of argument. However, the judge of compensation claims said in his order that there was simply no evidence that benefits were denied or that the guardian was instrumental in obtaining any benefits for the claimant directly related to the case. The judge of compensation claims never said in his final order anything about guardian fees being payable only if litigation ensues or if a petition for benefits is filed, or that the benefit had to be expressly denied by the insurance company. The judge of compensation claims never said that in his order, and therefore he did not impose a prevailing party analysis or make this analogous to a taxable cost against a prevailing party in a workers' compensation matter. The judge never took it that far.
Well, let's take a step back a little bit from the word benefit, right? So you don't quarrel with the fact that this incapacitated ward certainly needs someone to look after his financial affairs and to check in on him to ensure that to have an advocate for his medical care. You don't quarrel with that, right?
No, I don't quarrel with the fact that Mr. Lopez is incapacitated. He's in a vegetative state with no brain activity.
And he needs someone to look after his care. I mean, the statutes clearly provide that. So that there's certainly a benefit to having someone look after him, again, take care of his financial and medical needs. It seems to be that your argument is that that is not a workers' compensation benefit. Am I understanding you correctly?
I would not categorize it as a quote-unquote benefit, no. 44017 does allow for discretionary appointment of a guardian or some other person. It doesn't even have to be a guardian. It can be a representative or a designated person by the Department of Financial Services or the Judge of Compensation Claims. But what there is not found in the statute is any duty of any party, whether it be the insurance company, the judge, the department, or even the injured worker's family to appoint a guardian under Chapter 440. 44017 is discretionary, and the Florida Supreme Court has commented on that as well in the Allure Shoe versus Limberis case, that appointment of a guardian is discretionary in workers' compensation matters. So there is nowhere in the statute that requires the insurance company to do so. And as a practical matter, when an injured worker, and as the record evidence shows here, when the injured worker sustained his injury, the insurance company immediately tried to find out what was going on. When these things happen, the insurance company has to undertake an investigation. They obtain the medical records, they find out what the injury is, they find out what's wrong with the injured worker. The insurance company spoke with a family member who represented to the insurance company that, at least at the beginning, he would be taking care of everything, and that family member lived with Mr. Lopez. So the insurance company did what the family requested. The insurance company issued benefits, and within 1 month of the industrial accident, appellant's counsel filed a notice of appearance on behalf of the injured worker. We had attorney representation within a month of the accident. So appellant's argument is that the insurance company had some sort of duty, which is not found in the statute or any case law, to petition the probate court in Hillsborough County to obtain appointment of a guardian, and that just doesn't exist in the law. I mean, an insurance company is not in the business of representing an injured worker in court. An insurance company is not in the business of seeking a guardianship regardless of the wishes of the family or anyone else as to what they might do. But yet that's what appellant proposes the insurance company should have done. An appellant also proposes that a guardianship, and I think the court alluded to this earlier when they were asking questions of appellant's counsel, it's a chicken or egg situation. If we're to require a guardian because, as appellant contends, the incapacitated worker cannot possibly receive a medical benefit or an indemnity benefit without a guardian, then under that logic, a guardian would have to be appointed before any benefits could be provided to the injured worker, monetary or medical or otherwise. That seems to fly in the face of 440.015, which requires the quick and efficient delivery of benefits to the injured worker, which is exactly what the insurance company did in this case.
Let's return to the statute at issue 44017 and maybe explore maybe where Charlton got the securing the benefit rationale. That provision contemplates the appointment of a guardian, and it says to, quote, receive compensation payable to such person under this chapter. What do those words mean?
Your Honor, I read those words to mean compensation in terms of compensation benefits, indemnity benefits.
And is compensation defined under Chapter 440?
It is. It's governed by Section 440.15 in terms of indemnity benefits.
Okay. Thank you.
And 440.17, Your Honor, is absolutely silent as to who pays for the guardianship. It's silent as to who establishes the guardianship, who maintains the guardianship. It's silent. It doesn't impose a duty on anyone to set it up or pay for it. And again, it's discretionary by the judge of compensation claims. The judge of compensation claims didn't feel it necessary to appoint a guardian in the first hearing that was conducted in this matter on February 15th of 2021. In fact, the judge of compensation claims indicated during that hearing that he was concerned that he wanted some family involvement as to what's going on going forward in this case. Furthermore, appellant was represented by counsel within a month of the industrial accident. So what appellant is asking this honorable court to do is to add things to 440.17 that just simply does not exist in the statute. There is no requirement that the insurance company seek out appointment of a guardian. There's no requirement that the insurance company pays for it. And there's no requirement in the statute that the insurance company unilaterally pays for all guardianship services no matter what. Therefore, Your Honors, we're left with two things to focus on. One, the judge of compensation claims committed no error regarding his construction of 440.17 and the Charlton and Lavoie cases when he denied payment of guardian fees in this matter. And two, the judge of compensation claims got it right when the appellant failed to meet her burden of proving that she pursued or obtained any benefits on behalf of Mr. Lopez. And therefore, this honorable court must affirm the judge of compensation claims' final order.
Thank you, counsel.
Thank you, Your Honors.
May it please the court. Fundamentally, Your Honor, the question is this supposed to be a claimant monitored system, a claimant's family monitored system, and an attorney for the claimant monitored system? Or has our case law told us for the last 40 years this is a carrier monitored system? It's exactly what it is. It's a carrier monitored system. And so the carrier here cannot construct a willful wall of ignorance and put their head in the sand and say, hey, we're just going to give you, send you your checks to whoever and provide whatever medical care. There is nobody legally who is able to receive those checks. The claimant is an incapacitated person. I want to speak quickly to the preservation of error argument. All of these points were argued in a meaningful way before the judge of compensation claims. Preservation of error rules exist to prevent somebody from raising something for the first time on appeal that's not been argued meaningfully before the JCC below. That didn't happen here. It's kind of a red herring what the appellees have thrown at you. And insofar as the motion for rehearing, the rule specifically says it is, number one, to challenge rulings that were outside of the scope of the issues presented. That has nothing to do with this case. Or number two, to seek clarification in matters of law that the JCC may have overlooked. The JCC didn't need to clarify anything. He was very clear about what his position was. So if you look at the body of the rule, in addition to the rule saying, don't re-argue points you've already argued, which is exactly what the invitation of the appellees is, to properly preserve error, which would do nothing but invite sanctions. I would humbly submit to you that this is not a preservation of error case. The question was asked, and I think it's a good one, Judge, where does sort of the authority for this emanate from, right? We know it starts, it's most recently Avoy, then it goes back to Charleston. And so the question becomes, where did Charlton get it from, right? And Charlton got it from, two key points. Number one, Charlton talks about the cases which construe the statute, speaking strongly in terms of the judge of compensation claims obligation to ensure that the interests of the mentally incompetent or persons are protected, number one. And number two, the overriding purpose of the Workers' Compensation Act, and we've talked about this almost ad nauseum, both before the JCC and as part of our brief, that you have to place benefits in the hand, that 440.015 requires that the carrier deliver benefits into the hands of the injured worker. You cannot deliver benefits into the hands of an incompetent person. Without a doubt, without question, Mr. Lopez needed a guardian to receive those checks and to make those medical determinations. And so the issue in this case is not whether the carrier should have went out and got a guardian or not. That's a conflating of what the issues are. The issue of who bears the primary responsibility for establishing and paying for a guardianship that is necessitated as a result of the compensable injury so that the claimant may receive his benefits, and so then the guardian may exercise all of the statutory directives. Your question, Judge Rowe, does it pertain just to indemnity? No, it does not. Section 440.17 talks about the judge of compensation claims may require a guardian to exercise the powers, and that's to receive compensation benefits and to exercise the powers granted to or the duties required of such person under this chapter, right? Those powers granted to this person are to get medical care. So the guardianship obligations under the statute aren't just confined to medical care only, indemnity. They are also confined to apply to medical care. And with that, Your Honor, we respectfully would submit that the judge of compensation claims erred by denying all of the guardianship costs, fees, and expenses and must be reversed on those grounds. Thank you.
Thank you, counsel. Thank you both. This court will stand adjourned.
All rise.